Mr. Stubbs, you have the floor.
Okay, is Mr. Olsen ready?
Yes, he's ready.
Okay. Hey, Mr. Olsen, I'm confused because my question that I seem to have a hard time getting a straight answer to is a preliminary question. It's a setup question. It's not even it's a foundation question. And how long have you practiced as a criminal attorney?
Well, for about 30 years.
Okay. So you have to know that a citation is a criminal complaint, correct?
Yes.
And that another criminal complaint is one that can be filed by the prosecutor.
Right.
Correct?
Correct.
Right. So I've had to ask so many times the simple foundational question of whether the citation is a separate case from the 2016 criminal complaint, and you don't seem to be able to answer that. Why can't you answer that question?
Well, it's not as simple as that. Some cases will include every charge in the criminal complaint. In other cases, there may be a citation and a criminal complaint, and we'll either negotiate to include them all as one case. There's a variety of different ways that those citations and criminal complaints can be disposed of.
Okay. Are you trying to be an obstructionist right now, Mr.
Obstructionist?
Yes.
Your Honor,
are you trying to not answer questions?
I'm sorry?
Are you trying to not answer my questions?
No.
Okay. Are you being coached by anybody there?
No.
Okay. We can't see you, and so forgive me if I have suspicions, because it seems like I'm asking simple questions, and you answer one way, then you answer another, and it just goes around in like circles, and it's taking forever because I can't get straight answers from the beginning. Are you in any way communicating with anybody there to help you testify?
No.
Okay. So the very simple, fundamental criminal law 101 question of whether Exhibit 1 and Exhibit 2 are separate cases. Can you answer that question?
Yes, Exhibit 1 and Exhibit 2 are separate cases.
Thank you. Thank you very, very much. It took us 10 minutes to get there. Now, you dismissed both cases, correct? On June 22nd, 2016.
We dismissed the criminal complaint 16 BC 0735. And
you dismissed the citation, correct?
Yes.
Okay. But with the citation, you didn't need to review any NHP video, did you?
I'm sorry, I'm losing your train of thought. I can't.
Okay.
What do you...
I'm asking a question. Don't worry about my train of thought. Just answer the question.
Okay. Ask the question.
I'll repeat the question. You did not need any additional evidence to prosecute the traffic citation, did you?
Are we talking about count 2 or both count 1 and count 2?
No, we're talking only about the traffic citation. We're talking about Exhibit 1, which is the separate case from Exhibit 2. And you dismissed both on June 22nd, 2016, but we've established they're separate cases. So just looking at the citation, did you need any additional evidence to review in order to move forward with the traffic citation?
I don't think so.
Okay, you don't think so. What other evidence could you possibly have needed to look at for the traffic citation?
I don't know. I don't think there's any other evidence needed other than the citation.
Okay, so you had all the evidence you needed at the time you dismissed it on June 22nd, 2016, correct?
I guess so, yes.
Okay, but then you recharged it after Mr. Hunt filed the civil federal rights lawsuit, correct?
That would be count 1 in the revised complaint?
Yes.
Yes, that was a mistake on my part, no question about it.
What was a mistake?
Filing that charge. If we had already disposed of the citation, and
so you admit that that was vindictive prosecution?
No, I don't.
What was the mistake then of you filing the charge after you'd already?
Well, now that I'm sitting here looking at it, I'd have to say that we dismissed the citation along with the other 2 counts and everything else that came
Did you discover any new evidence for the traffic citation that make your case stronger?
No.
Did Tara Thackeray leaving the office impede you from refiling a traffic charge?
No.
Did your pending retirement, did that interfere with you filing a traffic charge?
No.
Okay. When was the last time you even did a traffic ticket?
That would be hard to say.
So Gary Booker generally does the traffic tickets, correct?
Had a very smooth operating organization.
But you made the decision to take the traffic ticket away from Gary Booker and just dismiss it without a deal on June 22nd, 2016, correct?
No.
You didn't.
That is not correct.
Then what happened? You dismissed the charge that was otherwise Gary Booker's to prosecute.
Dismissed without prejudice.
Okay. But again, you did not discover any new evidence on the traffic charge. And then you filed it again in a criminal complaint after Mr. Hunt filed his civil rights lawsuit, correct?
That would be correct.
Okay. Isn't that the very definition of vindictive prosecution?
I don't believe so, no.
Okay. All right. And nobody there is communicating with you in any way during this entire time?
No.
No looks, no nods, no winks, nothing?
Nope.
Okay. I do find it interesting that after I call that out, all of a sudden I get through my outline in just a few minutes, where for one question it was taking 10 minutes before. But thank you. Okay. I'm done with the witness, Your Honor.
For cross-examination.
Thank you, Your Honor. Mr. Olsen, we've gone through a number of exhibits, and I just want to go through a timeline with you. So based upon exhibit number 2 of the City of Boulder City's exhibit, the original criminal complaint was filed on June 13, 2016. Is that your understanding?
Yes, that is correct.
And then at Exhibit 3, which we've looked at quite a bit now, was a motion to dismiss. And that motion to dismiss was filed on June 21st, 2016. Is that your understanding?
Yes, that was a motion to dismiss without prejudice.
Objection.
Okay.
Objection. stating incorrect facts, facts not in evidence. I believe it was the 22nd.
All right. Well, why don't you, clarify that on redirect if you'd like to.
Yeah, there appears to be a file stamp on the top of this document that it was filed on the 21st of June. And it appears that that's the date that it was signed by Mr. Olsen as well. So the document itself is the best evidence. It speaks for itself as to the date. So with respect to exhibit number 2, and we've taken an opportunity to look at that now, or rather exhibit 3, sorry. Exhibit 3, the motion to dismiss, you include an affidavit along with this motion, did you not, Mr. Olsen?
Yes.
And what were you attempting to convey to the court by way of this affidavit?
Facts that justified granting of a dismissal without prejudice.
And does Nevada law allow a prosecutor to dismiss a criminal complaint and without prejudice to refile that criminal complaint later in time?
Yes.
And are you aware of what that statute of limitation is to bring misdemeanor charges against any individual?
1 year from the date of occurrence.
Date of occurrence of the event in question.
Yes.
And I'll ask judicial notice be taken that the citation that was issued was June 8th, 2016. In your affidavit that you stated that there's some additional evidence that you had not had an opportunity to review and were looking for time to review that evidence. Is that an accurate statement of what you set forth in your affidavit?
Yes.
And after you submitted this motion, did you have an opportunity to review additional evidence?
I believe so, yes. I'm not exactly sure on that.
And at some point, did you not file a new complaint based upon the review of this new evidence?
Yes.
And is that the complaint that is identified as exhibit number 4 that bears the date of June 5th, 2017?
Yes.
So according to Nevada law, is it your understanding and testimony that this new complaint was filed in accordance with Nevada law prior to the expiration of the statute of limitations?
Yes.
Now, there has been some testimony already about what may have jogged your memory. You previously testified that you had spent time working on this complaint throughout the year, but it had fallen under the stack of papers, if you will, or off of your priority list at some point. And you've also testified that the service of the federal civil action filed by Mr. Hunt jogged your memory. Did you in any way, shape, or form, Mr. Olsen, intend to vindictively prosecute Mr. Hunt by the refiling of new charges against him?
No.
Had you been working on these new charges prior to the filing of this civil action by Mr. Hunt?
Yes.
Does Nevada law allow you to refile the charges and even add additional charges if the evidence so indicates against a criminal defendant?
Yes.
Do you believe that the evidence that you reviewed in your duties as city attorney supported the causes of action that were ultimately brought against Mr. Hunt?
Yes.
And were you involved in the criminal trial of Mr. Hunt as a witness?
I was.
Do you know what the final adjudication of that case was?
I don't.
Objection, relevance, and hearsay.
Yeah, it's sustained. That's, that's a public record. You just refer the court to whatever, document.
I think he answered he didn't recall as well, so we'll move
that's
on.
fine.
Thanks, Your Honor. I have no further questions. Mr. Olson?
Right, redirect, Mr. Stubbs.
Yes. So, Mr. Olson, does vindictive prosecution require intent to vindictively prosecute?
You know, I haven't looked at that statute, so I'd be remiss to try to say it from memory. I'm sorry.
Okay. Are there certain legal activities that prosecutors can't do if they otherwise violate somebody's due process or First Amendment rights?
I don't understand the question.
Okay, let me put it this way. There's state statutes that tell you what you can do, correct?
Right.
Okay. Then there's case law and federal statutes in the United States Constitution that also tell you what you can and can't do, correct?
Yes.
Okay. So isn't it true that you have to separately act in a way that does not violate both state law and someone's constitutional rights?
Yes.
Thank you. That's all, Your Honor.
Thank you. Is there any recross?
No, Your Honor.
Right, Mr. Olson, you're excused from testifying. Mr. Stubbs, you may call your next witness.
John Glenn, please.
By September 6th, you will pay $6,000 of what is due.
Best interest is not, can you give her a pony?
Ask the question, make sure we're being accurate with what the document states.
Overruled. Let's just get through this. I want to know what the facts are.
To find out what the facts were. I agree, the record's a mess.
I make a finding that paternity has been established.
He was a potential danger to his children.
Trying to pull up my outline for Mr. Glenn, just a moment. Hello, Mr. Glenn.
Hello.
Are you there? Is Mr. Glenn there?
Yes.
Yes, I'm here.
Do we want to swear him in?
Yes, why don't you stand, raise your right hand, and be prepared to have your oath administered.
Do solemnly swear the testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you. Please state and spell your first and last name for the record.
John Glenn, John Glenn.
Thank you, sir. You may be seated. Mr. Stubbs, proceed.
Sergeant Glenn, that is still your rank, correct?
Yes, it is.
Okay, so Sergeant Glenn, were you in charge of the crosswalk enforcement action on June 8, 2016?
Yes.
Did you send out a press release about the enforcement action on June 4, 2016?
There was a press release sent out, yes.
Did that press release instruct the citizens to use the crosswalk?
No, it did not.
If you could please look at exhibit, Mr. Hunt's exhibit 2.
Hold on.
Give me a second. Okay.
Okay. 4 lines down. Well, first of all, what is that?
It's a press release sent out by the Boulder City Police Department.
Okay, and at the very top, who are you supposed to contact in the press release?
Sorry, say that again?
The very top, where it says for immediate release, and then down below, who's the contact for the press release?
I am.
Okay, so did you write this press release?
No, I did not.
Did you send out this press release?
No, I did not.
Was it sent out by the department?
Yes.
Can you authenticate it?
It appears to be the press release that the department sent out, yes.
Thank you. In the first paragraph, 4 lines down, starting with Nevada state law requires, I'm going to read that. If you could just read along and make sure I read it correctly.
Okay.
Because Nevada state law requires pedestrians to use sidewalks, crosswalks, and pedestrian bridges. Did I read that correctly?
Yes.
Okay. Does that not instruct people to use the crosswalks?
No, it's not.
Well, it says Nevada state law requires pedestrians crosswalks.
Yes, it does.
So how does that not instruct people to use the crosswalk?
I don't see anywhere in here where it says you're instructed to use the crosswalk. That's just advising them of Nevada state law.
Okay, and if they violate, if a police tells you that you have to obey Nevada state law, isn't that instructing someone to do that action?
Depends on the context.
Okay, all right. Were there any signs telling people not to use the crosswalk?
Not that I'm aware of.
Did anybody tell Mr. Hunt not to use the crosswalk prior to you arresting him?
I did not tell him. I don't know if anyone else did.
But you are not aware of any notice being given to Mr. Hunt, correct?
Not aware of any notice, no.
Okay. Did there come a time that you found out that Mr. Hunt was protesting by crossing across the street in the crosswalk?
There came a time where I was advised that he was issued a citation for not stopping for a pedestrian in the crosswalk.
Okay, then did you admit that he was making a political statement?
That's a statement I made.
Okay, so you told other officers that you knew that Mr. Hunt was making a political statement, correct?
No, I did not.
What did you say then?
I said he was making a political statement. It was a term that I used. I wasn't telling him that he was making a political statement.
So you told officers that he was making a political statement by crossing the crosswalk, correct?
The phrase that I used, yes.
Okay, great. Whose job was it to gather evidence in this case?
City Attorney's Office, I would imagine.
Did there come a time when you submitted evidence to the city attorney for prosecution?
I submitted a report paperwork to the city attorney's office.
Okay. Did you
I
submit to
did
them?
personally, but I didn't
I'm sorry,
personally,
go ahead.
my department did.
The department did, okay. Who was in charge of getting Dave Olsen the NHP videos?
I don't know.
Did you inform Dave Olsen of the existence of the videos?
I don't believe I did.
Do you know when he received those videos?
I do not.
Would it surprise you to know that on June 10th, 2016, according to NHP's records, those videos were copied and sent to your department?
I did receive a copy, yes.
Okay, when did you receive a copy of them?
I don't remember.
Was it on or about June 10th, maybe a little afterwards of 2016?
I really don't know. I know it was close to the time of the arrest. I can't tell you when.
Okay, so very close to the time of the arrest, you received a copy of the NHP videos, correct?
Yes.
Okay. Within a week?
I don't really know. It's been too long.
Within 2 weeks?
I don't know.
Okay. Okay, I'm finished with this witness, Your Honor.
Thank you. Cross-examined?
Yes. All right, Sergeant Glenn, previously, Mr. Olsen was asked some questions regarding what I believe is exhibit number 8 in that binder that you have in front of you.
Yes.
You'll turn to that.
Have it?
And do you recognize that document?
Yes, sir, I do.
And there was some testimony given with respect to a specific set and phrase that was found in your report. In the phrase being, I believe, stopped before hitting Mr. Hunt.
I'm going to object, Your Honor, as relevance. We're not supposed to get into whether or not, Mr. Glenn or Sergeant Glenn did things correctly. Those questions were specifically the mindset and what City Attorney Olsen was thinking when he wrote notes. And so it's not fair that they get into all this.
Well, but you opened the door by asking questions about what was in the report, and so I'm going to allow Mr. Glenn to explain his interpretation of what was in the report. So go ahead.
And Mr. Glenn, if you would explain your interpretation of what you meant by your report.
Basically what it says, there may be a comma missing, but it says here that the vehicle in the number 2 lane was able to stop. However, the vehicle in the number 1 lane had to slam on its brakes and skid to a stop just before, I'm sorry, I lost my place here. Had to skid to a stop just before hitting the subject.
So in your report, are you trying to allege that the vehicle hit Mr. Hunt?
Absolutely not.
Okay. And so what you intended to infer was that the vehicle actually did stop before hitting him,
Correct.
but did not hit him.
That's correct. It skidded to a stop before hitting him.
Okay. No further questions?
I'm done.
Is it disputed here whether he was hit or not, Mr. Stubbs? That's what I'm trying to understand.
You were just breaking up, Your Honor.
Yeah, is there a dispute on whether Mr. Hunt was hit or not? I mean, I know you were drawing a comparison between Mr. Olsen's note in the right column and then the actual words of the citation, but that goes to whether there's an inconsistency, not whether there was whether he was actually hit, right?
Your Honor, there was a dispute to it earlier, and in fact, there's a dispute. I can look for it and find it in some of the transcripts, but that dispute seems to have gone away. So it's no longer a dispute.
All right, very good. Thank you. That's helpful. All right, so redirect exam.
No more questions,
No,
Your
I
Honor.
didn't do any questions. I don't believe you can redirect if I don't do any questions.
Oh, wait,
I
we
think-
had, all
I
right, so
believe,
is, is everybody done with their questioning of this witness?
yes, Your Honor, thank you.
Yes.
All right, very good. Sergeant, thank you very much for your time. You're excused, sir.
Thank you, Your Honor.
All right, Mr. Stubbs, you may call your next witness.
Mr. Gary Booker.
All right, is
Your
Mr.
Honor,
Booker still with us?
he is here, Your Honor, but I would object to this witness. Mr. Booker is a prosecutor for the city and prosecuted this case at trial. And so I can't imagine any substantive information with respect to any of the claims or allegations in the motion by Mr. Stubbs, or Mr. Hunt rather, that would be relevant with respect to the anticipated testimony of Mr. Booker.
Your Honor,
Did
Mr.
he
Booker
have
was noticed.
any role in the decision-making on whether to file the second complaint?
No, he did not.
All right, and do you know if he was consulted by Mr. Olsen on the issue whether the second complaint should be filed?
No, he was not.
Mr. Stubbs, what would be his relevant? What would be the relevance of his testimony if he wasn't involved in that decision making?
Well, first off, I'd point out that he was duly noticed, and they have filed no objection to this court, right? And as to the relevance, I intend to show that Mr. Booker, representing the city, gave course and conduct against the First Amendment that seems to, that will actually make it even clearer that the city of Boulder City actually regularly violates First Amendment rights in this case with two specific instances. And I believe that's very important on the First Amendment portion of my motion.
You need to give me more specifics than that.
Okay, so
there needs to be. Oh, go ahead.
First of all, Mr. Booker in trial made a motion for the court to confiscate Ms. Dickhutt's notes. I want that testimony because that clearly shows that they have no regard for the Sixth Amendment guarantee to a public trial, and there are First Amendment implications there. Additionally, during the proceedings, Mr. Booker asked Judge Victor Miller to issue a gag order against me that has since been declared to be a violation of the First Amendment. That gag order was because I publicly criticized Steve Morris, a public official, and I simply said that he did not care about Mr. Hunt's First Amendment rights. I made a Facebook post. Mr. Booker then made a motion to the court and to Judge Miller to issue a gag order against me so that I could not speak about the case. That gag order was then overturned by Judge Johnson, Susan Johnson of the District Court, on a writ, and it was declared a clear violation of my First Amendment rights. All of those things, Your Honor, show a course of conduct in this specific case with violation of First Amendment rights the exact same way they're doing against Mr. Hunt.
None of that, though, was the basis of my original minute order regarding vindictive prosecution.
I believe it was.
In fact, that wasn't, I don't remember that even being in your original brief where you sought to dismiss. The focus of your original brief was the timing of the filing of the second complaint, and not any conduct of Mr. Booker. Let me look. I have your complaint here. Give me your motion.
Honor, if you just look at the minute order itself, because there's two motions that I put out. One was a First Amendment motion. Now, in making that motion, I have to do that motion based upon evidence, and all I had at the time I made that was I didn't have much. This is an evidentiary hearing to where I can now prove things up. And it's very, very relevant And in fact, Your Honor made a finding in the minute order that the city violated Mr. Hunt's First Amendment rights on the obstruction charge. That was an issue, and Your Honor made that with that minute order. Now, this is an evidentiary hearing to where I'm supposed to prove up, the allegations, and I now have an opportunity of a witness that has been duly noticed that they did not object to until right now, to where he can add extra evidence in support of Boulder City's systematic violation of First Amendment rights in this case. Systematic. It certainly makes it more likely that they violated Mr. Hunt's First Amendment rights.
I'm looking at my minute order. Give me a moment. So I do make a reference here to there being the charge of obstruction, despite knowing that Mr. Hunt was purporting to assert was asserting his First Amendment right of freedom of speech. That's what I put in there. So I guess, was Mr. Booker involved? I guess he was involved in the decision-making on whether to file the original complaint, right?
No, he was not.
I'm sorry, you said no?
I said no, he was not.
You're talking about 2016. I do not believe it had gotten to him.
Right.
However,
so then he didn't decide.
He was very involved in the 2017.
I think I'm hearing him say he wasn't involved in whether to file the obstruction charge at any point in time.
That is correct.
Your Honor, he vehemently prosecuted the obstruction charge. Just like you and me, he took an oath to uphold and defend and support, uphold, and defend the Constitution, including the First Amendment. And he vehemently moved forward with that charge. He is every bit a part of this vindictive prosecution because he actually acted vindictively in the prosecution with the First Amendment issue. He was a bulldog here, and he went
I understand.
forward, and then he went on.
I understand your position. I'm looking now. If you look at my minute order, I didn't find that. My minute order was that the charge should not have been filed in the first place. That's what I said in my original minute order before the evidentiary hearing. I didn't say anything about conduct in prosecuting the charge. But let me take a look at your motion, okay? Mr. Stubbs, do you say anywhere in here that it was vindictive prosecution to pursue the obstruction charge, or were you limiting your argument to the filing of the obstruction charge?
To pursue it? Well, I think clearly the vindictive prosecution at the case law is the act of filing and pursuing the charges. That's what vindictive prosecution is. Right? Why file a charge unless you're going to pursue the charge?
Well, I see that, but there's no dispute.
I didn't specifically set that out, but that's the natural part of what vindictive prosecution is.
No, of course, but you're missing my point. The point is nobody disputes that Mr. Booker prosecuted the obstruction charge. So the real question here is, should that charge have been brought in the first place? That's what we've been talking about. Right? It doesn't matter whether there was pursuit or prosecution of the charge, because if it's either the charge was brought properly or it wasn't brought properly. If it's not brought properly, then you don't even need to discuss, the efforts to pursue it. So I still don't understand what Mr. Booker is bringing to the table here in terms of relevance. There's no dispute. He prosecuted the charge.
I'll try to put it simply. This office has a course in conduct, specifically in this case, of continually violating First Amendment. One is, of course, is the one that's at issue here. But they have done it 2 other times with Mr. Booker. Twice. which clearly shows that this office does not care about the First Amendment, completely disregards the First Amendment. That's what they did in filing the obstruction charge, and that's what they did when they motioned Victor Miller to give me a gag order, which then was overturned and deemed a violation of the First Amendment. And that's what happened when Gary Booker asked that Ms. Dickhutt's handwritten notes be confiscated by the court. Now I ask you, Your Honor, there's the facts of how much you're going to weigh Exhibit 10. There's that fact. Doesn't it make it more or a heavier weight if Gary Booker, representing the city, is unconstitutionally advocating for the confiscation of handwritten notes? Clearly, they did not want that transcript to be made public. They didn't want it to come to this court, even though it's a true and correct authenticated transcript. They even made false allegations. In fact, Mr. Morris opened the door with that one because he made it at the very beginning, which Gary Booker argued in front of the court at trial. He opened the door on that one. He talked about it. And Mr. Booker argued to confiscate handwritten notes of an observer at trial. It has everything to do with the credibility of the city attorney's office. It has everything to do with you putting a lot of weight on Exhibit 10, that transcript. The fact is they didn't want it out because they knew they were caught. They didn't want it out because they knew. By the way, that motion was made after Mr. Olsen testified. They did not want this transcript out because it hurts them and it hurts their ability to even defend vindictive prosecution. It's wrong what happened, and Mr. Booker needs to explain himself.
Would you like to respond to that, Mr. Olsen?
Mr. Morris, yes, thank you, Your Honor.
Mr. Morris, yeah.
That's fine. Beyond the fact that it's utter nonsense, yes, I do have a few statements in that regard. The court is correct that this has absolutely zero relevance on the matter at hand. Zero. Zero probative relevance, zero evidentiary relevance. An attorney is expected to be a zealous advocate for his client. What Mr. Stubbs fails to mention is that this gag order included both parties. Both sides could not make, under this order, could not make any statements with respect to this matter. So it didn't apply to just Mr. Stubbs and his client. It equally applied to the city. Now, again, that's irrelevant to the matter at hand and to the underlying case and the manner in which that case was tried. It was tried successfully. There was a conviction to which now Mr. Hunt has appealed. He has that right to appeal. And so the manner in which that trial was conducted, again, Mr. Stubbs has a right to try that case de novo, anew. What he's trying to introduce is a fugitive report that Mr. Stubbs is now trying to hoist onto the city as being the bad actor, when it is Mr. Stubbs that is acting contrary to Nevada law. This is not a court of record, and he's trying to make it a court of record. Pursuant to his own argument today, Mr. Stubbs alleged that Mr. Olsen testified during trial about a matter that was not found in the transcript, thereby disqualifying his own transcript, which he claims to be true and accurate. But you heard him say during the questioning that this didn't find its way into this affidavit. The reality is there's a lot of things that didn't find their way into that fugitive transcript that he's now trying to pawn off as being authentic and approved somehow in some way in a court that constitutionally and statutorily is not a court of record, but he's trying to now make it one. That is problematic. That is troublesome. And so, and not Mr. Booker's conduct of, again, doing his job, right? There was no violation of any First Amendment rights, but Mr. Stubbs loves to shout that from the rooftops. And he does it in such a way that it is full of inaccuracies, misrepresentations, and it really borders on ethical and professional violations, and I'm tired of it.
Your Honor,
The one thing that's going through my mind is whether Mr. Booker had a good faith belief that the obstruction charges had merit at the time he was prosecuting them. I think that might have some relevance here. The other stuff, I don't think so much. I'm thinking of allowing him to be examined on his belief and understanding as to the validity of the obstruction charge, because I think that goes to the whole point about whether there was vindictive prosecution. That's the exact point of Mr. Stubbs' motion, is that this obstruction charge should not have been pursued at all. So I could see that being relevant. The thing about the aggressive advocacy and trying to disallow and prohibit from anyone using the court recorder's notes, I don't see how that's relevant here. I mean, that's simply an attorney's aggressive actions to try to recognize that Boulder City trials are not courts of record. So, Mr. Stubbs, I don't see how that's relevant at all. Besides, because you have the transcript now, and they didn't destroy everything, so it's not like they achieved any kind of litigation advantage here. They were simply saying under the law, this is not a court of record. This shouldn't exist. What state of mind can I derive from that?
Your Honor, not being a court of record has nothing to do with being able to take notes or a transcript. In fact, the court can allow recordings and it's still not a court of record. The fact of it being a court of record deals with all kinds of evidentiary, not just at trial, but at every point, and only determines whether or not an appeal is a new or not a new. Because a court of record, which by the way is more expensive, way more expensive, which is why Boulder City and only one other city are not courts of record. All that has to do with is whether or not, or how the appeal goes. There is no law that says that what I did was illegal. None whatsoever. Judge Whitaker said specifically, no recordings of any kind. You can do what I'm doing, which was taking notes. Right? That's what she said. But at the same time, again, they cannot point to one law that says you cannot have a handwritten transcript with a court that is not a court of record. There is no law. They keep saying that, but it's just not true. And the fact that Mr. Booker wanted this transcript to be destroyed, he wanted the court to take it and destroy it. He asked for that. That tells you all you need to know.
Yeah, but where is that in your motion?
It's not.
Well, then I mean, that's what I asked at the very beginning of this. What is the scope of your contention that there is vindictive prosecution, and you're adding stuff that wasn't in your motion?
I'm adding evidence that wasn't in the motion because this is an evidentiary hearing to prove up the motion. And I believe this is very relevant to how that office conducts itself, and it supports that they are more likely than not to violate someone's First Amendment.
It has nothing to do with the fact that this is an evidentiary hearing. It has it relates to what was your theory of vindictive prosecution. And your theory was that there was a new complaint close in time to the civil complaint. That was your theory. And you didn't have a theory in here that there was an attempt to destroy the transcripts.
But, Your Honor, this has to do with the second part. There's two parts to this motion. One is vindictive prosecution, and the second is a violation of First Amendment rights, where the actual charging of obstruction, to wit, walking in the crosswalk. They're mad because he was protesting in the crosswalk. He was literally charged with protesting in the crosswalk because he was protesting, and he was charged with walking in the crosswalk. And Your Honor found that in your minute order. And now I'm asked to prove that up, and I'm trying to give all the support, including Gary Booker asking Judge Miller to violate my First Amendment rights in this case, and because whether or not the order was for both sides, Gary Booker didn't ask for it for both sides. Gary Booker asked to gag me, and that happened. And they clearly disregard the First Amendment. And if they have a course in conduct of disregarding the First Amendment, it makes it more likely that they did so against Mr. Hunt with the charging of the obstruction. I'll submit it to the court on that. I repeated myself a couple times, but I believe this is relevant.
All right. Gentlemen, just give me a moment to finish looking at the original motion here. I'm waiting for my court clerk to come back. She had to step out for a moment. All right, she's back. So, in going through the motion, the theory was the timing and severity of the new charges and the fact that, or the allegation that these new charges were unfounded. What it seems to me that Mr. Stubbs, what you would like to do is expand on your theory and the evidence in support of those theories for vindictive prosecution. You want to explain to the court there are additional activities and course of conduct of the city that would support your theory of vindictive prosecution. So from a procedural perspective, I'm wondering if the more appropriate thing to do, unless it's already too late, is for you to withdraw this motion and file a new motion which gives proper notice to the city of all of the theories upon which you're pursuing. And I don't even know if there'd be time for that. I don't know if that would be...
I will not call Gary Booker. If that's what it takes, then I will set that aside and I'll just...
That wasn't my ruling. I was trying to see if procedurally the right vehicle might be for you to do a new motion so they have proper notice, an opportunity to address it.
I'm not interested in doing that, Your Honor. So if that's what you're saying procedurally needs to happen, I will not call Gary Booker.
Well, I'm just worried about the due process argument that I would hear from them if I were to allow you to pursue on issues other than the timing and severity of the new claims.
I would argue that the time to object would have been earlier and not the day of the hearing. They could have objected to Gary Booker being called. They could have made all these arguments, and when I gave notice in March, they didn't.
We did object.
They did not object.
Whether he needs to be available to testify is a different issue than the scope of the testimony that allow him to give. Anyway, did you have anything that you wanted to say on this, counsel? Anything further?
Are you referring to the city, Your Honor, or Mr.
Yeah, or the city. Anything that you wanted to say and to add on this, Mr. Morris?
Thank you, Your Honor. And I believe that Mr. Stubbs has withdrawn his request or desire to question Mr. Booker. So I think that would resolve that issue at this point.
I will reserve, however, depending on Steve Morris's testimony, maybe that will make Mr. Booker relevant in a different way. So I'll reserve.
Right, you can reserve. Sure, I'm not making a ruling then as to whether Mr. Booker might become relevant at some later step in this proceeding. So for now, Mr. Booker, you're not being called. Okay, sir? And let's go ahead and call the next witness.
Steve Morris, please.
All right, Mr. Morris, now it's your turn to be sworn.
Well, Your Honor, I have the same objection to my testimony, which I did object to ahead of time. I have, much like Mr. Booker, I have even less involvement in the criminal side of this matter. While I was a contract attorney for the city during part of this time, it was strictly on the civil side. So I was not involved in any way, shape, or form in the discussions or the filing of any of the complaints that you have before you today. And in fact, I was only tangentially involved in this matter in an evidentiary hearing that took place after the criminal complaint was filed. I took over the duties as the acting city attorney after Mr. Olsen retired in late June of 2017. And so my actual start of official duties, I believe, was on or about the 26th of June, if I'm not mistaken, of that year. So any probative.
Go ahead.
No.
Yeah.
So
did you Go ahead.
So with respect to the underlying issues in the original criminal complaint and the subsequently filed criminal complaint, I had no involvement whatsoever in that. During the actual trial of the case, yes, I would have had supervisory authority over Mr. Booker at that time for the actual trial. So the same rationale that applies to Mr. Booker would apply to me in this case. And I should further note, Your Honor, that this is done simply in an effort to harass the city attorney's office. There's no probative value here. There's no rational basis to question the attorneys that tried this case with respect to Mr. Booker and myself. And it is done in an effort to harass the city attorney's office, which Mr. Stubbs has done for many years now.
Well, the timing, the whole reason why we're here, Mr. Morris, is the timing of the second complaint and the circumstances under which the severity was increased. The charges were increased in severity, suggest or raises some concerns to the court. The timing's suspicious. And that's why we're here, to allow the city to explain itself. And
sure.
So I see no problem at all in Mr. Stubbs trying to explore the facts and circumstances surrounding why we ended up with this second complaint. And it's probably relevant to know, the state of mind of the actors leading up to the second complaint. And
which he is,
go ahead.
Sorry. Which he has already done with the prior city attorney, David Olsen.
What was the scope of your supervision of the prosecution of the obstruction charge?
So again, I didn't assume this office until after Mr. Olsen had retired. All the events in question happened prior to Mr. Olsen's retirement, right? So I had no supervision over any of that. Once I took office and this matter was going forward towards trial, yes, I would have had supervisory authority over Mr. Booker. But Mr. Booker, as testified by Mr. Olsen, really handles that side of matters very skillfully and with, quite frankly, little to no supervision of myself. As I previously stated, I was involved in an evidentiary hearing that was requested by Mr. Stubbs that brought in expert witnesses to testify regarding the authenticity of the video in question, right? And so I was involved in that portion of the case. That was really the extent of my involvement in the case, because Mr. Booker tried it. And I don't believe, I'm trying to recall, Your Honor, if I was even there during any part of that trial, and I don't recall, quite frankly, that I was. It is stated by Mr. Olsen, this is a very small office here. It is myself, I have a paralegal, and for some of that time I did not. Mr. Booker is responsible for the prosecution of all criminal matters. And so my time is spent primarily on the day-to-day administrative matters of advising my clients, which are the city council and the appointeds and the administrative staff and department heads. And so that really takes up the bulk of my time. So again, the level of oversight of Mr. Booker is de minimis, very minimal. Mr. Booker is a tried and proven career prosecutor, and quite frankly has much more experience in that field than I do. So again, any probative value that I may have would be even less. Any probative value of my testimony would be less of that of Mr. Booker under the circumstances.
And, Your Honor, may I clarify? Steve Morris is being called because he filed the documents that were submitted to the court, his opposition. That opposition contains false statements that are not supported by an affidavit. And he's using those false statements, he's using that false evidence as a defense in this exact action. And so I am calling him to question him about his
But any statements, any factual statements in a brief, I disregard completely unless they're supported by admissible evidence. I don't, I don't give any credence or credibility or weight to any purported factual statement in a brief. Like I said, unless it's supported by admissible evidence, and this hearing would be the time for the parties to come forward with evidence. So other than that, I give it no weight. Now,
But I need one more part, Your Honor. It's specifically because Mr. Morris claims that certain things were said at trial. A trial that we have the only transcript of, that he makes these statements not knowing there's a transcript, but we have the only transcript. And so in his defense, he twice makes statements that Dave Olsen said certain things during trial. Now, he just told you he wasn't there. So how is it that he can make statements, factual statements about the trial, not supported by the affidavit? Well, actually, part of it was supported by an affidavit that I think I've shredded pretty well with Dave Olsen, and Your Honor has taken note of some things that were simply not true. But Mr. Morris makes claims of what Mr. Olsen said at trial and then purports to use those as a defense. That is what I have to clear up, because it's in the documents that's before this court.
I think it's too collateral, though. I'm not going to. Your case isn't prejudiced at all by this, Mr. Stubbs. I'm not going to give any weight to anything that Mr. Morris said in a brief, unless it's supported by evidence. And if he said something in there that you believe the evidence contradicts, then point that out to me in closing argument. That's the way to do it.
Okay, I will do that, Your Honor. In that case, I have no further witnesses.
All right, thank you. So then that means the appellant rests, and Mr. Morris, the city may call its first witness.
And we don't have any further witnesses, Your Honor.
So the city has no evidence, no additional witnesses other than the witnesses that it cross-examined, I suppose.
That's correct. In the redirect that we provided as well, obviously, Your Honor, is the exhibits in brief that we have provided to the court. That is the sum total of the evidence that we have presented for the court's consideration in this matter.
So I do think it would be of great assistance to the court if I did receive argument from the parties. And I would prefer to receive that argument because there was a lot that came out today that was a little bit different than what I had seen before in the briefs. So I would definitely benefit Mr. Stubbs and Mr. Morris by some argument. And I'm thinking the best way to do this would be to have written argument rather than oral argument. But I'd like to get your opinions on that. And plus, it might take you both some time to put together some of the points that we discussed today. I know for a fact, Mr. Stubbs, you're going to need some time to put together some of the arguments that you want the court to hear. Because you told me
I'm
that.
ready. I'm ready right now, Your Honor. And I would object because that gives the city an opportunity to do additional things that they did not do. You ordered briefing on this. We briefed it. That's
All right.
what's here.
All right.
And
I thought you wanted argument.
That the
So,
city, yes.
well, I thought you wanted argument. Are you suggesting that I just take this matter under submission now without any argument?
No, I'm suggesting we don't do written argument. Like you said at the very beginning, Your Honor, give us both 10 minutes, give us a clock, let us go. And I would,
Mr. Morris, what's your...
Your Honor, Mr. Stubbs has introduced some extraneous material, and if he intends to utilize that in his closing argument, we obviously want an opportunity to deal with that because, as the court stated and recognized, that is not included in his motion.
It is, though.
It is not.
Look at the report.
Oh, Mr. Stubbs, proper decorum here. You can't interrupt him when he's in the middle of a sentence because I gave him the floor to speak, right? All right, go ahead, Mr. Morris.
So in that regard, Your Honor, yes, we would appreciate an opportunity to have at least some notice is to those allegations that Mr. Stubbs is now raising outside of his brief.
What are you specifically referring to that's outside of the brief that you're concerned about?
Well, he's trying to make statements now that it is more likely than not that the city would have vindictively prosecuted Mr. Hunt based upon the actions of the city attorney's office. It's preposterous. And so if he intends to go that direction, obviously we want an opportunity to respond because that's clearly extraneous material that was not included in his original motion. And so if he intends to go down that road, then obviously we'd want an opportunity. Furthermore, Your Honor, either way, we're happy to submit on the briefs that have been presented as well, because it is my position that apart from this extraneous material that Mr. Stubbs is trying to present, that all the evidence has been included. And this is the best evidence that's there. And we believe that in our brief, we go through methodically and identify the law as it applies, how it is applied, how it has been applied by other courts that have reviewed the same legal and evidentiary arguments that Mr. Hunt has made there and how they have ruled. And so, again, we believe that those arguments based upon vindictive prosecution have been laid out. Mr. Olsen did not testify contrary to anything that has been presented thus far, whether it be in his affidavit or in his deposition, which is also included in the record that's before the court. And so in that respect, this is a very straightforward issue as far as we are concerned. And that is that vindictive prosecution is impossible under the circumstances, because the very action that the city attorney took at the time, Mr. Olsen, is endorsed by our Nevada law, right? And so the simple fact that a criminal, or a civil, federal civil complaint was filed in the interim does not abrogate Nevada law on those points and on that issue. It does not. And if it did, you would have a race to file situation where any criminal defendant would say, as long as I get my civil complaint on file before they refile any criminal charges, I'm good to go, because it would be per se vindictive at that point. That is not the law, and far from it, but that is what Mr. Hunt is advocating. So either way you want it, Your Honor, we've taken a lot of your time today.
Sounds like that already was a closing argument. So I'm going to allow. Can I speak? I think I'm getting feedback here. I wasn't sure.
I think you are. Sorry about that. Yeah.
No problem. Well, I'm going to allow Mr. Stubbs to present his closing argument in any appropriate manner in any manner that he deems appropriate. I'm going to take him up on his suggestion to limit him to 10 minutes. And you've already had several minutes, Mr. Morris, but if you want to add anything, you have the right to do that. I'll give you 10 minutes also. If you believe that there is any argument that was improper or making arguments beyond the evidence that was introduced in this case, you can file later a motion to strike any of the argument if you think that is appropriate, and then I'll consider any motion to strike before I make a ruling here. But I am going to allow the argument and give Mr. Stubbs leniency in presenting his point of view here.
Very good. Thank you.
And I will point out, the court didn't allow me to go to those extemporaneous things, so I'm not going there. I'm just not. So that doesn't matter. Thank you, Your Honor. My brief sets out very well the entire law regarding vindictive prosecution, the entire thing. Now, they claim that because there's a state law that says that they can dismiss and refile, that they're okay. The problem is that they also have to obey federal law, specifically constitutional law, specifically the Due Process Clause. That's what vindictive prosecution is all about. They had 11 months plus to file this other complaint. They didn't do it. They didn't. And they had Ms. Tara Thackeray all the way till April 6, 2017. They didn't do it, and only did it after Mr. Hunt filed his civil rights complaint. Everything would have been perfect until then. There was no race to file. In fact, there's other case law not presented because it's not valid here that says exactly what Mr. Morris had a problem with. But first of all, vindictive prosecution is a prophylactic measure. This is U.S. v. Jenkins and DeMarco. Prophylactic measure intended to prevent a chilling effect of defendants exercising their statutory or constitutional right. And the burden that I have is not beyond a reasonable doubt. It's not more likely than not. It's an appearance. If there is an appearance, is what the case law says, of vindictive prosecution, then we have to go through everything, and the vindictive prosecution will most likely be upheld unless there are certain defenses. Now, that appearance can be made only by timing, according to U.S. v. Jenkins. That's exactly what happened in that case. The timing created the appearance, therefore, they went through vindictive prosecution. Now, once I meet my appearance burden, the other side has to satisfy a more likely than not defense by proving that it wasn't vindictive prosecution. And the United States Supreme Court said actual intent to vindictively prosecute is irrelevant. 100% completely irrelevant. So Mr. Olsen saying, I didn't mean to do it, that doesn't matter. It doesn't matter at all. That's irrelevant, okay? What is relevant? What's relevant is whether the government, that would include in this case, City of Boulder City Police Department, Nevada Highway Patrol, whether the government had in their possession all the evidence they needed to further the prosecution. And they did. They did from the beginning. They still dismissed the charge. And the fact that they waited, and we waited almost an entire year to file that civil rights complaint, the fact that they waited makes it vindictive prosecution. The Ninth Circuit has said the mere appearance, Okay. Now, they have to, and they have not. They have not said anything except, state law lets us do it. Problem is, federal law doesn't. Okay? The NHP evidence was legally in the possession of the city attorney. He had plenty of time. He didn't do it. He didn't do any of that. And again, it says the government. It doesn't say government attorney. There's other cases that say government attorneys. It says the government. From Jenkins, courts are particularly inclined to find vindictive prosecution when the government had enough evidence to bring charges, but held off on bringing charges until just after the defendant exercised a right. That is exactly what happened here. They held off. They were given plenty of time. Over 11 months is plenty of time. Plenty. They had it, and they held off. Vindictive prosecution. They could find another way for them to defend this is to say there's newly discovered evidence. I asked City Attorney Olsen, said, when was this discovered? And he said, before June 22nd, 2017. How do we know that? He filed an affidavit saying he knew about it. All the evidence they're talking about, the NHP videos, is not newly discovered because it was discovered prior to even dismissal. And that's deemed to be in the prosecutor's hands because it's the government. So there was not any newly discovered evidence. And frankly, if you look at this, the affidavit of Mr. Olsen claiming that Tara Thackeray is the problem, that's baloney, Your Honor. Complete baloney. She wasn't gone until April 6th. Though that detail wasn't put in there. It wasn't in there. But that is a detail nonetheless. And the fact of the matter is they tried to deceive this court by making it look like there was a long period of time when there wasn't. There wasn't at all. Your Honor, what's very telling here is that there were two separate cases in 2016. Two. One was the citation. The other one was the separate criminal action. Both were dismissed. Both of them. And you heard Dave Olsen testify that he was not waiting for anything in the first citation. That all makes sense. It makes sense. They could have moved forward with a traffic ticket. They chose not to. And they did that because his intent was to dismiss everything. And that's what he did. And then he only filed the charges later on. Now, he's made so many inconsistent statements. If you compare it to the trial transcript, he has made so many inconsistent statements that he is not credible with any affidavits or any defenses. I picked apart his affidavits, especially the Tara Thackeray part and his timeline. He says he doesn't remember. He said a number of things, and everything that he said was contradicted by his own testimony under oath through the trial transcript. The fact is that they dismissed and then they refiled, which increases the severity of the charges. They filed additional charges, which again increases the severity of the charges. This is a prophylactic rule. So with all the press this has gotten, what's the likelihood that because Mr. Hunt has had to go through this, that somebody else is going to file a civil action? Doesn't it show that, hey, if you do this, we're going to hurt you. If you do this, we're going to put you through all of this. That's what this shows. It's a prophylactic measure to stop the chilling effect. I'm asking you to stop the chilling effect. And I would point out that that was your ruling prior, and the the Nevada Supreme Court was presented this on writ, and they denied the writ. They put a stamp of approval on your ruling and what you did. Okay. Another thing that they can do, according to Hooten, is present independent reasons or intervening circumstances to dispel the appearance of vindictive prosecution. They have done none of that. Best they came up with is, I'm retiring, according to Dave Olsen. Well, okay, but you weren't retired. You still had a job to do. And the fact that you're retiring, that doesn't mean that you don't have your job to do, and you're not set by the same constitutional standard. Now, going to the First Amendment, Dave Olsen wrote in his margins, and he did it in 2016. He recognized the First Amendment issue. John Glenn, he admitted to multiple officers that he knew Mr. Hunt was making a political statement. The Judge Mahan in the federal court made a ruling that Mr. Hunt was protesting. What was the manner of his protest? Going through the crosswalk. Guess what? He was authorized to do it. Dave Olsen admitted to that, and I had to pull teeth to get that, and I had to show him his own transcript to where he admitted to that. He was never given any notice that he couldn't go in the crosswalk. No officer said, hey, look, we're doing this, you're not allowed to be here. That didn't happen. No evidence whatsoever that he wasn't allowed to be in that crosswalk. All he was doing was protesting, and the obstruction charge only says he was obstructing because he was using crosswalk. Had nothing to do with the manner of use of crosswalk, had to do with the crosswalk. The city violated Mr. Hunt's First Amendment rights. They upped the ante. They did the wrong thing. What the court did originally is the correct thing. And, Your Honor, if you don't do exactly what you did before, it's not going to stop the city from doing it again. They need to follow federal law. They need to follow due process rights. And according to the United States Supreme Court, that's what this is. It's a vindictive prosecution is prosecutorial misconduct for due process. They don't want someone afraid to file a civil complaint, to exercise a constitutional right. And that's why Your Honor needs to do the exact same thing they did before and dismiss this case on vindictive prosecution grounds and on First Amendment grounds for the obstruction charge. And I will submit to the court. Under 10 minutes, by the way, Your Honor.
Right. That was, well, I think that was 12 minutes.
9:47.
Thank you. All right. Let me hear from the city. Mr. Morris?
Yes, Your Honor, thank you. We appreciate the time and your attention to this matter. I find it ironic that Mr. Stubbs states that we didn't follow federal law when this case has made it all the way up through the Ninth Circuit with the same claims, defenses, and causes of action that Mr. Stubbs is alleging in this particular matter. And the city has prevailed on each and every one of those claims. Each and every one, including a claim of malicious prosecution that was brought in the federal court action. At no time did the federal court ever find that the city violated Mr. Hunt's rights in any way, shape, or form, nor was he maliciously or vindictively prosecuted. And so we encourage Your Honor to consider that, to look at that, because that is an absolute misstatement by Mr. Stubbs that the city has not followed federal law. We have followed it in every respect. His analysis of vindictive prosecution is just wrong. It is patently wrong. It is erroneous. We, instead of reiterating these points, Your Honor, I would just draw the court's attention to pages 14 through 20 of the city's memorandum, where the applicable standard in law is set forth in great detail, including references to the evidence and to the record that has been provided. The reality of this is that, Mr. Stubbs likes to make this out to be a protest. Well, that's not how this case began. It only became a protest after Mr. Stubbs was retained. Mr. Hunt, in his own words, stated that he intended to walk across this crosswalk to infinity. That clearly is not protected speech. When asked if this was, what he was doing, he simply said that he was going on a walk. He did not express at any time when he was first confronted by our officers that he was protesting in any way, shape, or form. It was only until Mr. Stubbs got his hands on this that it became a First Amendment issue. And so it's important to note that, and it is important.
Facts, not in evidence. He did not present anything of what he's talking about. He had his chance and he didn't. And I'm sorry to object closing arguments, but he did not prove it up.
All right, Mr. Stubbs, since you do have the burden of proof on the defense, you will get the last word. Why don't you save your comments? I'll give you, 2 minutes at the end so you can make those points and make sure that.
Again, Your Honor, it is set forth in the exhibits that have been provided, and Mr. Stubbs has not objected to any of those exhibits. So again, that is part of the record that is before this court, and it was, and that record was identified in our moving papers, in our memorandum. And so that is properly before the court for the court's consideration, where each of those exhibits are identified and proper references given thereto. And so we have a situation where they're claiming that this is a protest and protected speech. It is clearly not under any case law. What Mr. Hunt did is not protected speech in any way, shape, or form, and that has been conclusively determined by our Federal District Court and our Ninth Circuit Court of Appeals, who also held that it is clear, based upon the video evidence, that Mr. Hunt did indeed violate state law in his efforts to walk across that crosswalk. Again, that is found in our memorandum and in our papers, that they found that he had violated that. And as part of this, I would encourage the court to take a look at the videos that have been included as exhibits in this, because it shows very clearly that what Mr. Hunt was attempting to do, and that is snarl traffic, violate the law, and he was prosecuted accordingly for it, and he was found guilty. Now, Mr. Hunt clearly has a right to a de novo trial, and that's what brings us here today. This is perhaps the third time that he has brought these motions in this proceeding, and he has failed in every respect, and he has not only failed in the what we would consider the state court, municipal court, district court, but he has failed in federal court in every respect. And so, again, Your Honor, instead of rehashing the legal arguments that we've already set forth in detail with citation to the exhibits, I would draw the court's attention again to pages 14 through 20 of our memorandum that sets forth the actual standard of what constitutes vindictive prosecution, or for that matter, a violation of First Amendment rights. And the court will see that it is not the standard that is being proffered by Mr. Hunt in this matter. And we would submit on that, and we appreciate your time, Your Honor.
Mr. Stubbs, I'm going to give you the last word on this, but let me also ask you this. I don't remember anybody authenticating the videos in these proceedings. I mean, not just today, but before. But do you want, what's your position on whether I should look at the videos?
Your Honor, they asked for an evidentiary hearing after you already made a ruling and Supreme Court agreed with it. Then they squandered this opportunity completely by not putting on any new evidence. They did some cross-examination with nothing.
Let me stop you. Look, so I'm not going to look at the videos unless you stipulate for me to look at them. So that's up to you. All I'm saying is, do you want me to look at them?
No, and you should not look at anything that wasn't presented today or authenticated today. That's what an evidentiary hearing is.
Well,
and they did not do it.
Okay.
Okay, now, first of all, look, you prosecute civil things in the civil courts, criminal things in the criminal court. Vindictive prosecution is not a civil cause of action. It's a separate criminal cause of action. You can be okay civilly, but not okay criminally. The civil courts decided that the First Amendment retaliation, which is completely different, but that's continually what they're arguing, a civil First Amendment retaliation. They decided on that. That's fine. This is vindictive prosecution, completely different and only dealing with the criminal courts. So, Your Honor, it doesn't matter what the civil courts did. It doesn't matter at all. Their arguments about First Amendment retaliation don't matter. The only thing that matters from the federal courts is the ruling that we both agreed with that Mr. Hunt was in fact protesting. And guess what? John Glenn knew about it and was telling other officers. Dave Olsen knew about it and was writing in the margin. They knew about it and they said it, and you heard their testimony that they knew that he was making a political statement. That's the First Amendment. That's the obstruction charge. The rest, I'm the only one who submitted a full analysis of vindictive prosecution. They actually submitted partial analysis from a few little things and completely ignored Jenkins. In fact, they asked you to ignore Jenkins, which is the controlling law in the Ninth Circuit. Nevada's in the Ninth Circuit. Appearance standard, Your Honor, and all we're talking about is dismissal of the criminal case. Whatever happens civilly, happens civilly. It's the dismissal of the criminal case, and it's just simply not correct what the city has said.
Thank you. Well, are we done, counsel, with the evidentiary hearing then? Anything else that either one of you needs to put on the record that's not already on the record?
I believe we're done.
The city is done, Your Honor. We appreciate your time.
All right. Thank you both. So this matter is under advisement. I am going to set down an in-chambers hearing date 3 weeks out. The clerk will give you that date. That date is merely for record-keeping purposes to make sure that this court has completed issuing a decision in this matter.
What's the date, Your Honor?
Yes. Pardon me?
What's the date?
Yeah, the clerk's looking it up right now. Oh, August 13, she says.
Oh, wait, this is going to be on Chambers?
Yes, Chambers.
Maybe make it that following Monday?
Sure. August 18th. This is on set down for in-chambers status check. August 18th.
17th.
17th. All right, we're going to get this right. The 17th. And that's just for internal record-keeping purposes. It's my intent to have a decision before then, and we'll make sure that that's been done on August 17th. All right?
Thank you, Your Honor.
Thank you.
Yeah.
We got it done today.
Don't worry about that then. I'm sorry, I was just finishing something with my court clerk. All right. Thank you, counsel. Thank you for getting it done. I appreciate it. Have a nice day.
You too.
All right. Bye. Off the record?